Well, good afternoon and welcome everyone to Western New England University School of Law's Constitution Day Clayson talk with Professor Angelique EagleWoman. My name is Julie Steiner. I'm on the faculty here at Western New England University School of Law. And one of the great privileges I have is to direct the Institute for Legislative and Governmental Affairs. And in that capacity, I wanted to just take a moment to recognize the meaning of Constitution Day, which officially took place last week on Thursday. So, as many of you likely know, on September 17th, 1787, the founders of our country signed the United States Constitution. And so each year, we commemorate the anniversary of this event. Over the years, we've done this in a variety of different ways, doing so like we are today through engaged discussions about the meaning of our constitutional values. We have held naturalization ceremonies to welcome in new citizens to the country. And last week, we honored our respect for our right to peacefully demonstrate by holding, and many of us attending, a Black Lives Matter rally here on campus. We're not a perfect union, and over time, much has changed and much still needs to change. But the ability to change and to adapt, and the ability to hold ourselves accountable and better adhere to our constitutional values is part of our ongoing constitutional legacy. Just as a little point of process, I encourage you all to include any questions you might have for Professor EagleWoman in the chat room, which I will monitor throughout this session. And I now have the privilege of introducing you to the Dean of Western New England University School of Law, Dean Sudasetti, to provide opening remarks and to properly introduce you to our speaker.
Thank you so much, Julie. I appreciate that. And thank you, Professor Steiner, I should say, for helping us set the framework for what Constitution Day is and why this conversation is so important in terms of our national discourse and our commitment to the rule of law as a fundamental pillar in a liberal democracy. We have not, and we may not still always maintain the rule of law as a society, but it has to continue and to stand as a goal and an aspiration to which all of us, particularly lawyers, ought to strive. And it's in that context that I particularly welcome this conversation with Professor EagleWoman. I also want to thank everyone here for coming today and participating in this conversation, and to thank the faculty and staff at the law school who worked together to make this presentation and discussion possible. Today's program is sponsored by the Clayson Speaker Series, as Professor Steiner mentioned, but it also involves effort from the Center for Social Justice, the Color of Law Roundtable Series, the Institute for Legislative and Governmental Affairs, and the faculty's Diversity and Outreach Committee. And so I want to thank the faculty and administrators who lead those entities and support their work. It's worth mentioning too that these entities have sometimes independently and collaboratively put on a slate of programs this fall that focus on social justice and racial justice in a lot of different ways. And I hope you join us for some of those upcoming programs as well. So I want to turn to our speaker for today, and it is really my honor and pleasure to welcome Professor Angelique EagleWoman as our Constitution Day speaker. Professor EagleWoman is the co-director of the Indian Law Program and a professor of law at Mitchell-Hamline School of Law. She received her JD from the University of North Dakota Law School and her LLM from the University of Tulsa College of Law. She was notably the first Indigenous law dean in Canada, serving as dean of the Boer Alaskan Faculty of Law at Lakehead University. She has also served as a pro tempore tribal judge in tribal court systems at the trial and appellate levels, and has served as general counsel for her tribe. She also established the Native American Law, emphasis program at the University of Idaho College of Law. Professor EagleWoman teaches in the areas of Aboriginal legal issues, Indigenous legal traditions, tribal nation economics in the law, Native American natural resources law, contracts, and the business of law, and civil procedure. Her research interests include tribal-based economics, Indigenous sovereignty, international Indigenous principles, and the quality of life for Indigenous peoples. She also is a frequent speaker on issues of diversity, inclusion, and professionalism. So thank you, Professor EagleWoman, for being here today. I look forward to your talk, and I turn it over to you for your presentation.
Thank you so much, Dean Setti, for that kind introduction, and thank you for everyone that made this possible. I'm going to go ahead and begin the presentation with my PowerPoint. I'm going to ask people to please jot down your questions in chat, and then at the end of the presentation, we'll get to them. I really appreciate that. So I am Angelique EagleWoman. In my language, my name is Wambadi Awanwichake Washte Wiyang, which is good eagle woman who takes care of the people. I'm Sistan Wapton Dakota Oyate, and I'm actually in our homelands at Mitchell-Hamlin School of Law, but our established reservation is in what has become South Dakota, and I will talk about that a bit later. We've recently renamed our program here, so I'm the co-director of the Native American Law and Sovereignty Institute. And today we're going to take a journey on history and law, and I'm really looking forward to this and the information we're going to share together. So the title is The Rule of Law, the Supremacy Clause, and Permanent Homelands Through Treaties. The idea here is that we look at what a society, a nation state aspires to. And in the United States, the aspiration is the rule of law. And I'll keep coming back to that throughout the talk today. The Supremacy Clause is, of course, part of the US Constitution, and we'll talk about that. And then the permanent homelands through treaties that all of us have in the United States. We are all treaty people. We will get there. So here's an overview of the topics we're going to walk through. So first, Turtle Island, that concept. Next, we're going to look at how European religious doctrine was adopted into law by the United States. We're going to talk about treaties as the basis of US tribal relations and how tribal people are mentioned in the US Constitution. We'll talk about treaty interpretation by the US Supreme Court. We'll talk about this idea of plenary power that the US Supreme Court has decided that Congress has. We're going to look at eras of US Indian policy, a particular era, the termination era, and the flipping of land ownership for tribal people. Then we're going to go to US Supreme Court decisions about so-called disestablishment and diminishment. And finally, we're going to look at the McGirt versus Oklahoma decision that's very recent, July 9, 2020, and what I'm calling the return to the rule of law. Next, we're going to look at the UN Declaration on the Rights of Indigenous Peoples, and then talk a little bit about what it means to be in permanent homelands where we are all treaty people. So I'm giving you this artist rendition of the concept of Turtle Island. The indigenous people of this land see the area that has become known as the North American continent, usually through our accounts, since we use the legal term time immemorial, so before anyone can think back to and remember through our oral traditions, we've called this Turtle Island. And we lovingly embrace this land, and we talk about land itself as Mother Earth. So all of this is embedded in our understanding of our relationship, and it's a reciprocal relationship with Mother Earth. And this is going to be very different than what most 1Ls are taught in property law. But this is our worldview and our philosophy and our indigenous legal tradition. So we need to go back and talk about how the present law was formed. So we have papal bulls. These are documents issued by popes in the Vatican. And they've issued these documents, particularly Pope Alexander VI Inter Caetera in 1495, that have become known as the doctrine of discovery. And the idea here is that European Christians respected the lands of other European Christians. But if you were not Christian, then you were considered a pagan or an infidel, And Europeans who stepped foot on the land had superior title over the indigenous people of those lands, had the right to monopolize trade, and had the right to convert the indigenous peoples to Christianity. And the papal bulls gave this recognition. We see Portugal and Spanish as the two European nations that first use it, but then eventually the British kings also used the doctrine of discovery, and they issued charters in the 1600s for trading companies in what becomes Canada and the United States. And then we see the same language then adopted by the colonies in North America, all under the papal bulls. And then we'll see how the doctrine of discovery becomes highlighted in US jurisprudence and is, of course, outside the Constitution, but firmly embedded in US law. So the United States is going to assert that it has successor status to the European-based England to be able to assert the doctrine of discovery against indigenous peoples in these lands. So this is a map showing indigenous territories and peoples of what became a lot of the eastern New England states. The first treaty the United States signed was with the Delaware Nation in 1778. And this is still during the time when British subjects are rebelling against the British government and forming the United States. And so here is the treaty itself. And there's this wonderful place called Kapler's Digital Collections. And Kapler's put together all the Indian laws and treaties up to 1905. And it's housed online. So you can look this up. This is a free resource. So this is it. This is the treaty with the Delawares from 1778. And you'll see Article 2, that a perpetual peace and friendship shall from henceforth take place and subsist between the contracting parties aforesaid through all succeeding generations. So you might wonder why there was good faith given to the colonists by indigenous peoples, and it's language such as this. In Article 3, we see the United States asserting that they're asking for assistance from the Delaware Nation, and see it's Delaware Nation in the document because they're seeking independence from the King of England. If you look in Article 3, you'll also see that the United States is asking the Delaware Nation to aid their troops with supplies of corn, meat, horses, or whatever may be in their power for the accommodation of such troops. And then further down, to supply the United States with such a number of their best and most expert warriors as they can spare. So continuing with this treaty, Article 4 is going to talk about continuing trade, but I wanted to get to Article 6. So at the very bottom, you'll see this language, hold fast the chain of friendship now entered into. This is language that was used in the 1764 Treaty of Niagara, where 24 indigenous nations were called for a treaty council with British representatives. And so the United States is clearly using that to say we're forming a confederacy here, and actually uses those words and asks the Delaware Nation to invite any other tribes who have been friends to the interest of the United States to join the present confederation and to form a state whereof the Delaware Nation shall be the head and have a representation in Congress. So I'm sure not a lot of people are aware of this history. But then we go back and we look again at this map, and the history that is now in the area that became Massachusetts, we had warfare, disease, and destruction actually occur for the tribes. The Mashpee Wampanoag were the indigenous peoples of what became Massachusetts. Their ancestors did offer a meal to pilgrims in 1621. The whole idea around Thanksgiving, though, has a lot of problems because we also see Puritan ministers like Cotton Mather celebrating the massacre of the Narragansett and the Pequot tribes with feasts of Thanksgiving. So how it comes down through through mythology, it's very problematic. So this mill was probably in the summer in 1621. But they fought for federal recognition. They have not been federally recognized by the United States, and that was finally gained in 2007 with the Bureau of Indian Affairs taking land into trust status. That's what happens for reservation lands. They go into trust status with the United States. But then March 2020, this year, the Trump administration announced that the reservation was rescinded. And I have this excerpt from the Cape Cod Times where it's reporting that after a federal judge stopped the rescinding of the reservation, the Department of Justice is now seeking an appeal. And you can read this quote from the tribal chairman, Cedric Cromwell, saying there was no warning, no justification, no reasoning given to suddenly have their reservation revoked. And so I'm saying that's outside the rule of law, and we're going to continue to talk about how the United States interacts with tribal nations around land. So when we talk about the US Constitution, we see Indian tribes expressly mentioned one place, and that is under congressional power. Article 1, Section 8, Clause 2, to regulate commerce with foreign nations and among the several states and with the Indian tribes. We often refer to this in the field of Indian law as the Indian Commerce Clause. But this is it. This is the only constitutional power that's mentioned in the Constitution of the United States regarding Indian tribes. And notice it's just about commerce and regulating commerce. It has nothing to do with regulating land, people, jurisdiction. But we're going to see from the Indian Commerce Clause all of this power the United States is going to claim as plenary power. We also see in Article 2, Section 2, talking about the U.S. presidential power, that the president shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. And this presentation is about treaties with tribal nations. So that's the presidential power. And then finally, one of the key parts that we're discussing today is the Supremacy Clause of the Constitution. This is Article 6, and it states, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. So again, treaties with tribal nations are part of the supreme law of the land. We often don't see that mentioned in the cases adjudicating or interpreting treaties with tribal nations. Finally, we do have a provision about excluding Indians not taxed. Federal taxes do apply on federal reservations now. And tribal members who work off reservation also pay state income taxes. So this is a recognition that tribal nations were separate entities with their own governance and engaged in commerce with the United States. So that's it for the constitutional basis of the relationship. Next, I want to talk a little bit about tribal sovereignty and what that means. It's an Anglo-Saxon concept that means the king can do no wrong. You might remember this from your torts law class. The king can do no wrong, and so the government must waive its sovereign immunity for suit, and you see that in like the Federal Torts Claims Act in the United States. So the sovereignty concepts adopted by tribal nations to hold the settler nation, the United States, at bay from encroachment. So although this wasn't a concept within the tribal worldview, it is adopted as the basis of the treaty-making relationship and to continue to assert the existence of tribal nations. The U.S. has continued to attempt to narrow the definition of tribal sovereignty to the present. We see that in US Supreme Court cases largely. So there's a concept of self-determination that's understood under the United Nations Charter as involving 4 factors: a people governed, a territory, domestic law, and foreign relations. And so we're going to look at US Supreme Court cases that say tribal nations are not nation states, and they are going to curb the ability of tribal nations to engage in the 4th factor, foreign relations. From the tribal perspective, we say tribal sovereignty is held in the hearts of the people, and so will go on for as long as we do. I also want to highlight the differences in the relationships, the treaty relationships, viewed from the tribal nations perspective and the British Crown to US perspective. So for tribal nations, we've had a long history of relationship building prior to British and French arrival. We see engaging in confederacy, alliance, and treaty relationships as sacred promises. These are agreements that are made ceremonially. They're often memorialized in song, oral tradition, pictographs, and other means. We have oral histories that contain the meaning of the treaties. We see our obligation as extending to all future generations. We see treaties as allowing settlers to share our resources. Most of us do not believe that we sold land or that newcomers could actually give us land that was our homelands. From the British view and the US view, we see that treaties were seen as an expedient and efficient means to acquire land for settlement and commerce. The treaties were for the United States are all written in the English language using legal terms, and I showed you that in the first treaty. We'll see that the courts are going to adopt some interpretive tools around that. Treaties were necessary and continue to be to establish legal title to lands in the United States. And we'll see the effort to seize lands where possible without entering into treaties. And also in the United States, we say that all of the treaties have been abrogated, either partially or fully. And we'll see even more of this as the US Congress is said to have plenary power, absolute power. So we have these 3 foundational cases that really set up the current situation for tribes and the United States. And we call them the Marshall Trilogy, named after Chief Justice John Marshall. So the first one comes down in 1823, and you may have seen this in your property text, Johnson versus McIntosh. There were no tribes that were party to this decision. It is 2 land speculators who are asserting title. One saying that they negotiated directly with a tribe, and the other saying they claim title through the United States. In this decision, we see the doctrine of discovery applied, and the United States is said to be the successor to Great Britain, and therefore gain the exclusive right to and superior title to all lands that the United States is going to claim, and that they can get the underlying title. They have superior title. They can get the underlying indigenous title in 2 ways: either to purchase that title from the tribes, and that's a treaty cession, or 2, to conquer the tribe and seize title. And most tribes dispute that they were ever conquered. When the US comes to you and asks for a treaty, that isn't an acknowledgement of being conquered. That's a government coming and wanting to engage in sovereign to sovereign relations with you. So we also see in 1831 and 1832, 2 cases involving the Cherokee Nation, where the newly established state of Georgia has a backdoor agreement with the United States that the United States is going to remove the Cherokee Nation from the lands now claimed by Georgia. If Georgia relinquishes its western boundary, when the state of Georgia is created, it says it has a western boundary to the coast. So that's to what would be California now. The United States says if you move your western boundary to a much more manageable size, we're going to remove the Cherokee Nation. The Cherokee Nation does not know this and has multiple treaties with the United States. They sue Georgia as Georgia begins to survey their lands and seize their property. In this decision, the US Supreme Court coins a new term And we also often say that in the area of Indian law, the Supreme Court is legislating, where they're the branch that's not supposed to legislate. They're supposed to just apply the US Constitution. So they coined a term domestic dependent nations for tribal nations, and they use this ward to a guardian language, and they look at the Indian Commerce Clause. So remember, the Indian Commerce Clause is to regulate commerce with foreign nations, among the several states, and with Indian tribes. And the reasoning is that because foreign nations are mentioned separately, the Indian tribes are not foreign nations, and therefore they have no standing under Article 3, Section 2 to sue in the US Supreme Court. Next, we have a US missionary who has the authorization of the United States and the Cherokee Nation to be in the Cherokee territory. And Georgia has passed a law that you must swear an oath of allegiance to Georgia to be in the Cherokee territory. The missionary refuses. So I know it looks like Worcester, but we pronounce this Worcester. So in Worcester versus Georgia, we now have a habeas petition from a US citizen that will be heard by the United States Supreme Court. And it's held there that Georgia does not have the ability to preempt federal treaties. Again, we have the Supremacy Clause that say treaties are the supreme law of the land, and that there will be federal preemption over state laws in Indian affairs. The treaties with the Cherokee Nation are to be upheld, at least on paper. During this same time, we have a president that is very anti-tribal. President Andrew Jackson signed into law the Indian Removal Act of 1830 and coerced over 70 treaties of removal to lands west of the Appalachians, and is supposedly said to have said to Chief Justice John Marshall, you've made your decision, now let him enforce it, about upholding Cherokee Nation treaties. We also see in 1871 a rider to an Appropriations Act saying that no Indian tribe or nation within the territory of the United States shall be acknowledged or recognized as an independent nation with whom the United States may contract by treaty. So remember, you can't modify the US Constitution by a federal law enactment. So this can't modify the power of the president to enact treaty or enter into treaties, or the Senate from ratifying treaties. What this does is really signal to the president that any treaties entered into will not be funded by the House of Representatives or through Congress. So this is constitutionally suspect in terms of the way it sets up how treaties are to be made. In the US Supreme Court, we have canons of construction that are used to interpret treaties with tribal nations. The thing is that the US Supreme Court does not want to totally nullify treaties, because in doing so, it's going to disrupt the title, the legal title to land with the United States. And so to justify settlement and ownership of US claimed territory, the treaties have to be maintained. So that's sort of the cynical view of these canons of Indian treaty construction. And these are what they are. If there's an ambiguity in a treaty, they must be decided in favor of the tribe. But the US Supreme Court can get around this by saying there's no ambiguity. If a treaty must be interpreted as Indians would have understood them, so that calls in expert witnesses. And Indian treaties must be construed liberally in favor of Indians. So I want to note that these canons of constructions are also applied to federal laws and federal regulations that have been enacted specifically for the benefit of Indians. So this is the worst era of US Indian policy, and we call it the assimilation allotment era. This is when the US Supreme Court decides that Congress has plenary absolute power over tribal nations, and they do it through looking at criminal jurisdiction, lands, and then children. So we have a case in 1883, Ex parte Crow Dog, where we have one tribal member killing another tribal member. And there's a whole story that goes behind that, but for the interest of time, I won't go into it. But this happens within the Great Sioux Reservation, which is recognized by the 1868 Fort Laramie Treaty. And as the prosecution is brought in the Dakota Territory U.S. court, the court finds that it has, well, it goes up to the U.S. Supreme Court, and the U.S. Supreme Court finds it has no jurisdiction over this because the treaty recognizes jurisdiction within the tribal nation for criminal acts between tribal members. Congress responds and enacts the Major Crimes Act of 1883 and asserts federal criminal jurisdiction for felonies on all Indian lands. So this is just a blanket assertion. This gets challenged in 1886 in U.S. versus Kagama, and the U.S. Supreme Court doesn't say there's a constitutional basis for the Major Crimes Act. Rather, they rely on a policy rationale and assert that there's plenary power. These are the words that are used in the language of the decision. These Indian tribes are wards of the nation. They are communities dependent on the United States. This has always been recognized by the executive and by Congress and by this court whenever the question has arisen. So now we see we are moving away from the rule of law to policy rationale. We also saw that with domestic dependent nations. This doesn't come from any constitutional basis. Plenary power comes from no constitutional basis. The United States isn't supposed to be able to assert plenary power over anyone. We see this again in 1903 in Lone Wolf versus Hitchcock, where we have the 1867 Medicine Lodge Treaty with a provision that requires approval by 2/3 of adult males for any future treaties with the United States, and the United States is pushing for land purchases here. And the U.S. Supreme Court, again, does not apply the Supremacy Clause, does not apply enforcement of the treaty, instead says this is a political question within the plenary power of Congress, and Congress is assumed to act in the best interest of tribal nations. So this is, again, the worst era, and we see these precedents now as good law where Congress is said to have plenary power. From this plenary power, the Congress passes what becomes known as the Dawes Act after Henry Dawes from Massachusetts. He was first the representative and now he's a senator. As the representative, he was the one that proposed the 1871 appropriations rider to stop funding treaties, and now the General Allotment Act, which abrogated unilaterally all the reserved land provisions in treaties, divided treaties into parcels, and these are called allotments, and placed them under U.S. trust status. And it was for the President of the United States through the executive power to decide to allot a particular treaty. Now remember, at this time, the majority of tribal people did not speak English while all this is happening. And of course, there was no representation in Congress. So while this abrogates the reserved land provisions, there are other provisions of the treaties that continue to remain in force, such as hunting, fishing, and harvesting rights. During this era, we also see through this plenary power, the U.S. government imposing mandatory federal military style and Christian-run boarding schools on Native children. This is a very, very difficult intergenerational trauma experience that's hard to talk about. The children in these schools were forced to speak English and convert to Christianity. Their parents had no right to stop this. They were basically kidnapped. The parents couldn't visit them. And to add insult to injury, the United States directed the treaty payments that were due for land cessions to tribal governments to fund these schools. The children were abused in every way imaginable, physically, sexually, emotionally. It's a very, very sad era. The first Indian boarding school was the Carlisle Indian School that was established in Pennsylvania. And the military officer in charge of this, Richard Pratt, stated his policy as kill the Indian, save the man. The United States Indian boarding school policy, a white paper was adopted in Canada, and Canada followed that model. and set up mandatory Indian residential schools. In Canada, there has been a Truth and Reconciliation Commission recently with 94 calls to action to heal and restore Aboriginal Canadian relations, and with government apologies and monetary settlement amounts for survivors. We see nothing like that in the United States. And I would just mention that both my grandmother and my father were in boarding schools in the United States. Okay, so I want to show you this map of seizing of Native American lands, but I do want to tell you it is not completely accurate. It doesn't reflect land holdings by Indigenous people pre-1776 or the reservations in Oklahoma. So that gives you a visual representation of the land loss. And so we're going to continue now to talk about the remaining reservations, but I wanted to give you this as well. So scholars in the area of federal Indian law have tried to categorize the different eras. And so we talk about a pendulum swing between the United States understanding and recognizing our government to government relationship and totally disregarding our tribal nation status and wanting to not recognize tribal governments exist at all. So we talk about this as a pendulum swing. Others have talked about it as a perpetual wave machine, up and down, back and forth. So we talk about the treaty era and then the removal era, removing tribes west of the Appalachian Mountains, west of the Mississippi River. But this overlaps with the reservation era, where the jurisdiction of the reservations is acknowledged within the tribal nations. And then the worst era I told you about, assimilation and allotment. We're still dealing with the intergenerational trauma from that era. It swings back over to the Indian self-government era. We're going to talk about that, but it's short-lived. Because then next we see the termination of tribal government status era that occurs in the 1940s to 1960s. And the current era that we have identified is the Indian self-determination era from the late 1960s to the present, although we will still see some disregard of tribal nation status. So the Indian Reorganization Act of 1934 halted the policy of allotment in its very first section and extended the trust status over the allotted lands within reservations indefinitely. So when the trust status expired prior to this, states would impose property taxes, which tribal people couldn't pay, and then would foreclose and take the lands. So the trust status protects the land from state taxation. The Indian Reorganization Act provided a structure for reorganized tribal governments by adopting a constitution as approved by the Secretary of Interior. And over time, American Indians who don't agree with things, we often withdraw. That's what we do. They would call an election, no one would show up. And so in certain tribal communities, the Indian agent from the United States, the US Indian agent, would say that you had to come out and vote not to adopt the tribal constitution, otherwise you did. That, of course, is not how we understand voting in the United States or the rule of law. The BIA handed out boilerplate constitutions, And these had they have bylaws in them, so it looks like more of a club than a government. Most tribal nations had clan-based governments, and so this is a different style of government being imposed. On the positive side of this, the tribal sovereignty was legitimized in a constitutional document for those that adopted this, and that's familiar to the US structure. So that did help. It also provided for the Secretary of the Interior to take lands into trust for tribal governments, so to remedy the lands that were lost. I told you that the pendulum swings, so when it swings to the termination era, we get one of the worst cases on land ownership. And this one is the Teton clan of the Tlingit Band of Alaska Natives. And they sued because they said the US government came onto their land and harvested timber. And they sued for compensation under the Fifth Amendment of the US Constitution, the Takings Clause. And they said, this is our land, we've held it since time immemorial. Little did they know that this case would be used to completely take away all tribal land. So in this case, the US Supreme Court held that if the federal government has not recognized tribal ownership of land, the tribe does not have ownership of the land. And so if plot by plot, the US government hasn't went across the United States and said, oh, we see that you own that land. Oh, we see that you own that land. If there's no documentation, the tribal nation says this is our homeland, the US Supreme Court is now, based on this 1955 decision, said, you have no land unless we say you do. All right, so here's some of the excerpts from this decision. First, this leaves unimpaired the rule derived from Johnson versus McIntosh. Remember that 1823 decision? That the taking by the United States of unrecognized Indian title is not compensable under the Fifth Amendment. And again, this is true not because an Indian or an Indian tribe has no standing to sue, or because the United States has not consented to be sued for the taking of original Indian title, but because Indian occupation. So remember, the US asserted superior title with only occupation by tribal nations at the whim of the US government. But because Indian occupation of land without government recognition of ownership creates no rights against taking or extinction by the United States protected by the Fifth Amendment or any other principle of law. Next, we have one of the most negative quotations from a US Supreme Court case, and it says, every American schoolboy knows that the savage tribes of this continent were deprived of their ancestral ranges by force, and that even when the Indians ceded millions of acres by treaty in return for blankets, food, and trinkets, it was not a sell, but the conqueror's will that deprived them of their land. So again, there were two ways to gain title. One was through purchase and the other was through conquering. And so here it's getting mixed together and saying any sale was also conquering, and no Indian land is recognized unless the federal government has put it in writing. So this flipped land ownership. All the lands historically owned by indigenous peoples, no longer. And this is still good law in the United States. In a criminal statute, we have the legal term Indian country defined. This is defined in June 25th, 1948. This goes along with the Major Crimes Act to show where the federal government had felony jurisdiction within Indian country. And we have three categories of Indian country: reservations, the trust restricted land allotments, and what's called dependent Indian communities. So dependent Indian communities require federal supervision, and we often look to the Pueblos, who are now surrounded by New Mexico, because they held their lands in fee, but under federal supervision. So that's dependent Indian communities. So next we get to look at the current reservations and this idea of disestablishment and diminishment that the US Supreme Court has taken to take even more lands from the treaty-based reservations. So the legal standard that the court has announced is that the first and governing principle is that only Congress can divest a reservation of its land and diminish its boundaries. Remember the Indian cans of construction? The U.S. Supreme Court can say there's no ambiguity, so we don't need to apply them. And what has happened in these cases is the U.S. Supreme Court has looked at an allotment act under the General Allotment Act and said that it has changed the treaty established reservation. And I'm going to highlight 3 cases here, and I call these the attack of South Dakota. So the first one involves my tribe. This is Sinwaptin Oyate, and it's Dakota versus District County Court. And this case is used as a precedent for disestablishment by the U.S. Supreme Court. This occurred in 1975. It was a 6-3 decision, and it relied on an 1891 Allotment Act that allowed the U.S. government to purchase surplus lands. So 84 years later, 1891 to 1975, suddenly the tribes told your reservation is disestablished. In dissent, we had 3 dissenters. Justice Douglas states there's not a word to suggest that the boundaries of the reservation were altered. I will say that my tribe was not a party or amicus in the lawsuit, and we continue to assert the full reservation status as detailed by the 1867 treaty. Next, we have the Rosebud Sioux tribe, also in South Dakota. And the tribe brings a declaratory action, meaning they really expect the U.S. Supreme Court to apply the rule of law and uphold their reservation boundaries. So they bring a declaratory action that 3 congressional acts that have allotments made did not alter their reservation boundaries. We have another 6-3 decision that held that the Rosebud Sioux Reservation was diminished, although there's almost nothing in the congressional record. Remember our legal standard. This is where I keep going back to the rule of law and our supremacy clause. Then in Hagan versus Utah in 1994, Justice O'Connor solidifies a 3-factor test coming from these decisions and says, here are the 3 factors. 1, the statutory language. Well, shouldn't that be where we stop? But no, we have 2 other factors that are going to be brought in. 2, the historical context surrounding the passage of the Surplus Land Acts. So if you're going to look at historical context in the 1880s, 1890s, who is writing anything in the English language? This, of course, is going to go against tribal nations. 3, we have recognized that who actually moved on to open reservation land is also relevant. Now, tribes are not moving on to their own reservations. So again, this factor is going to go against tribes and say that as white people came onto the reservations lose reservation status. That is not the rule of law. Again, highlighting the attack of South Dakota in 1998, we have the tribe also seeking the rule of law by bringing a declaratory action as the state has approved a landfill, basically a trash site, within the reservation boundaries near the tribal preschool. Justice O'Connor delivers the unanimous opinion that the 1894 Surplus Land Act actually changed the reservation boundaries, diminished the reservation boundaries, applied this 3-factor test, and held that the landfill was on non-Indian former reservation lands outside of tribal jurisdiction. The McGirt decision. On July 9, 2020, we have a 5-4 decision, and Justice Gorsuch delivered the majority opinion. And I call this the return to the rule of law. Remember the legal standard here. The first and governing principle is that only Congress can divest a reservation of its land and diminish its boundaries. So we're looking for Congress to explicitly say that. And these words are worth repeating, so I'm going to go ahead and read this. This is how the decision opens. On the far end of the Trail of Tears was a promise. Forced to leave their ancestral lands in Georgia and Alabama, the Creek Nation received assurances that their new lands in the West would be secure forever. In exchange for ceding all their land east of the Mississippi River, the U.S. government agreed by treaty that the Creek country west of the Mississippi shall be solemnly guaranteed to the Creek Indians. So this establishes the reservation. On page 1, we also get, today we're asked whether the lands these treaties promise remains an Indian reservation for purposes of federal criminal law. Because Congress has not said otherwise, we hold the government to its word. That is the rule of law. That is applying the standard. So I've talked about these factors that have been used to find disestablishment or diminishment. And this is what the majority opinion addresses as these factors. So sort of a hypothetical is given here. And I'll go ahead and read through this. In the end, only one message rings true. Even the carefully selected history Oklahoma and the dissent recite is not nearly as tidy as they suggest. It supplies us with little help in discerning the law's meaning and much potential for mischief. If anything, the persistent if unspoken message here seems to be that we should be taken by the practical advantages of ignoring the written law. How much easier it would be, after all, to let the state proceed as it has always assumed it might. But just imagine what it would mean to indulge that path. A state exercises jurisdiction over Native Americans with such persistence that the practice seems normal. Indian landowners lose their titles by fraud or otherwise in sufficient volume that no one remembers whose land it once was. All this continues long enough that a reservation that was once beyond doubt becomes questionable and then even far-fetched. Sprinkle in a few predictions here, some contestable commentary there, and the job is done. A reservation is disestablished. None of these moves would be permitted in any other area of statutory interpretation, and there is no reason why they should be permitted here. That would be the rule of the strong, not the rule of law. In the dissenting opinion, we have Chief Justice John Roberts joined with Alito, Kavanaugh, and Thomas, and the four dissenters say, follow the previous factors. And here's an excerpt there. Under those precedents, we determine whether Congress intended to disestablish a reservation by examining the relevant acts of Congress and all the surrounding circumstances, including the contemporaneous and subsequent understanding of the status of the reservation. Yet the court declines to consider such understandings here, preferring to examine only individual statutes in isolation. So again, trying to push back and use these court-derived factors, which clearly go against the rule of law. I also want to talk about the UN Declaration on the Rights of Indigenous Peoples. This is a seismic change. This is a huge change as the first collective human rights instrument ever adopted by the United Nations, and has almost no mention in the United States, and we need to start teaching it. The US approved it in 2010. When it was first adopted by the UN General Assembly, the vote was 143 in favor, 4 opposed, and 11 abstaining. The abstentions were the Russian Federation, but the 4 opposed are what we call the settler nation states: Australia, Canada, New Zealand, and the United States. And since 2007, all 4 have now conditionally approved it, including the United States. What we have in the UN Declaration are new standards for indigenous US relations in all nation states. First, Article 19 sets a standard for states to have free, prior, and informed consent. We call it FPIC, before they take any measure that will impact indigenous people. This would reverse plenary authority. Article 26 recognizes ownership by indigenous people of their lands. This would displace the doctrine of discovery in the Tehitan 1955 decision by recognizing full ownership in American Indians and Alaska Natives. And then we talk about forums for adjudication. Article 27 says that nation states shall have fair processes to recognize and adjudicate the rights of indigenous peoples pertaining to their lands, territories, and resources. Again, we don't have that when the US Supreme Court disestablishes a reservation without the tribe as a party to the lawsuit or as an amicus to the lawsuit, relying on these factors of the contemporaneous understandings and who settled there. Article 28 talks about having a process for the right to redress and compensation, and that compensation shall take the form of lands, territories, and resources equal in quality, size, and legal status. And usually that's what tribes want, our lands back. Article 40 talks about dispute resolution processes. And I posit that the domestic courts of the U.S. have not provided neutral forums for the resolution of disputes, particularly around land, and that we should have a neutral international forum that would require the United States to assent to support a just adjudication of claims. Permanent homelands, and we are all treaty people. So again, a majority of the treaties entered into by the U.S. with tribal nations state the promise of perpetual peace and friendship. And tribal nations state that we have upheld the duties under the treaties. This should mean recognition of full human rights, the application of the rule of law to tribal nation claims, and fairness in court decisions. I also teach my students and talk to other lawyers about we have a permanent neighbor relationship between tribal nations and the United States. Neither of us are going anywhere. It's time to reconcile the past and provide a way forward. The U.S. is a settler nation state and must honor the treaty relationships with tribal nations. For tribal nations, we look at the impact of our actions on the next 7 generations. And we need to continue to do this work now to provide that our children have homelands. So the treaties provided permanent homelands for both tribal nations and the United States. The land title for the United States was established by treaties, executive orders, and congressional land recognition acts and settlements. And this should be taught at all levels of education. Finally, I want to sum up and say that I believe in the rule of law, I believe in human beings, and I believe that we educate, which is why I'm a law professor, and that we can change negative and discriminatory chapters of the past. I also have co-authored a book with Dean Emeritus and Professor Stacy Leeds that is sort of a primer and an easy to understand book on mastering American Indian law if you are interested in reading further. So with that, I will go ahead and open up to any questions people may have.
Thank you so much, Professor EagleWoman. This is Julie Steiner, and I just wanted to pass along a couple of questions that have come through in the chat room. The first is a question that asks, what have been the tribal nations' experiences and successes or failures grappling with hydraulic fracturing for oil and gas on tribal lands?
That's a big question, and we would have to talk specifically about different tribes. So I'm really not sure how to answer that. It's too big of a question. There's 575 federally recognized tribes. So some tribes are partnering or building corporations where they are looking to extract natural resources from their lands. Other tribes are not. Where the lands are under U.S. trust status, sometimes the U.S. government has approved those kinds of activities on tribal lands. So it's really too broad of a question.
Thank you. And what would a neutral international forum look like, in your opinion?
So we have the International Criminal Court. We have different courts out there. In the Inter-American Human Rights Commission, we have abilities to adjudicate claims, and there has been one successful claim brought on behalf of Western Shoshone members Mary and Carrie Dan against the United States with an advisory opinion coming out that the United States unlawfully seized the Shoshone lands. So, but the United States doesn't recognize the Inter-American Human Rights Commission to give any credence to that opinion. And so I would say we all know what court systems look like. It wouldn't be difficult to set up a 3, a 6, a 9 judge panel agreed upon by the United States and tribal nations. We have the National Congress of American Indians that has all of the tribes recognized and members of. So NCAI and the United States could come to an agreement on how to set up the decision makers in an international forum. So I would like to see that kind of forum set up.
How does the McGirt decision affect the cities in Oklahoma that are now in Native American territory?
Really does, well, it depends on the land status. So within a reservation, the tribal nation has the ability to pass laws on taxing, business licenses, things like that. What we see though, our tribal nations are usually very reasonable, agreeable, collaborative. We have alliances. And so what we'll see is we'll see a variety of memorandums of agreement and understanding. We already have that for taxes in Oklahoma. We have that in terms of gaming operations. So cities and towns are not going to be that impacted. The only thing that may change is you might see the tribal nations licensing more tribal businesses. That could be possible, but for the most part, it's not going to change much. It will impact within the reservation boundaries. If a tribal member is charged with a crime, then we have the Major Crimes Act, which puts it into federal jurisdiction, and the tribe has concurrent jurisdiction. So there's no double jeopardy for an Indian alleged perpetrator to be charged in both tribal court and federal court.
There's some real, powerful sentiments on the chat room about feeling despondency over this history, and a question really to you about what we can do in light of this, and what are your thoughts, I'm going to put this together, about how we could spread the word about the violent history to others, to increase our collective education and make sure that history does not repeat itself.
Well, here's this book. I would encourage faculty, whatever institution you're at, or teachers or instructors, to start teaching this. I think it's ridiculous in 2020 that I have law students come into my classroom who don't know that tribal governments exist. So our history is suppressed. We don't get media, mainstream media that is. We have court systems, we have constitutions, we have governments, and it is up to US citizens to not only educate themselves about tribal nations, but also stop this idea that there's plenary power by the US Congress over any people, but especially tribal nations.
Professor Charity notes that when he was in law school, he was taught that avoiding the US Supreme Court was often a win for tribal interests, and asks whether you think Justice Gorsuch's decision is an example of a shift in US policy toward federal Indian law, and what pressures are there towards greater recognition of tribal nation rights today.
So of course, we're all mourning the passing of Justice Ruth Bader Ginsburg. Justice Ginsburg had a very negative perception of tribes up until the McGirt decision. She actually, in the city of Sherrill versus Oneida Nation, put a footnote that said the United States gained title through the doctrine of discovery. She also authored a decision involving a North Dakota tribe in tribal court jurisdiction that said non-tribal members should not be held into unfamiliar courts. So we had not counted on Justice Ginsburg as an ally in terms of tribal nation decisions. However, with the McGirt decision, she joined with Justice Gorsuch in the majority, and that made a huge difference. So with her passing, we now have a 4-4 court. And a 4-4 court has actually worked for us in the past. When Justice Scalia passed and there was a 4-4 court, there was a major decision that came up to the US Supreme Court that would have impacted tribal court jurisdiction, but because the U.S. Supreme Court was deadlocked in terms of their decision on it, the lower court stood, and the lower court decision upheld tribal court jurisdiction. So we're in that situation right now, and it's really, it's a tenuous situation. I'm telling you, the rule of law has now been reaffirmed. But again, what happens next with the U.S. Supreme Court? That's why we need to teach this, and we need to educate people, because we do say we're in the self-determination era, but at any moment we could get a U.S. Supreme Court decision that impacts all 575 tribes. And there are still unrecognized tribes in the United States, legitimate tribes that are trying to go through the federal recognition process and reestablish their sovereign to sovereign relationship and their land base. So that's one way people could help, is to reach out to the unrecognized tribes, and they have websites and they call for donations and assistance, and there are things like that to do.
Thank you. Could you explain a bit more about these horrifying story of the schools that you described? How were those tribal children forced to, or actually the question is about the closure of those schools. How were the schools that they were forced to attend closed ultimately, and how widespread were those schools?
Well, in the 1880s up to about really 1975, with the passage of the Indian Self-Determination and Education Assistance Act, which allowed tribal governments to charter their own schools, the Indian boarding schools were in full operation. So, like I said, my father's generation went to those mandatory boarding schools. There's no way to stop, armed people from coming and taking your children. I have a son. It's difficult for me to even think about what generations of parents went through with that. So with the 1975 legislation, tribes were able to create their own tribal schools on tribal lands, but we still have a lot of American Indian children in public schools learning history heavily slanted against them, talking about savages, the Indian Wars. And so again, we need to continue to educate. The majority of the Bureau of Indian Affairs, is what we also call them, Indian boarding schools, were shut down in the 1970s. However, a few of them still remain and were changed into therapeutic model or public type boarding schools without the whole civilization training included. So there are a few left. There's one in Wahpeton, North Dakota. There's a few out there.
In terms of terminology, can you explain the proper usage of the terms tribal, Indian, and indigenous, and when you might properly use those three terms?
Okay, in a way, a lot of them are interchangeable. So we call it federal Indian law because the federal government uses the term Indian. And there's a whole section of the US Code, 25, USC, everything in there is Indian law. It pertains to us. And when our children were in boarding schools, they were taught the word for you is Indian. And so you'll see elders still talk about, I'm an Indian. That's the word I'm going to use. I'm not. Or more specifically, our own tribe. So Tustin Wahpeton, that's how I'd identify. But we use tribal nations. We use Indian tribe. Again, these are English language terms that we're trying to use to say who we are. In Canada, the word indigenous is frequently used, and we also see that in the UN, indigenous peoples. But indigenous can mean people who are not what we would call American Indian. So they're kind of used interchangeably. You can use American Indian. We also use Native American. But there's a funny story around that with people not understanding what that means. And often you'll see the mainstream media using, they're a native of Minneapolis. And we're like, what? Because a native to us means us, American Indians. But back in the 70s, Berkeley, on their college admission, put a category of Native American, and they said they had 13,000 Native Americans apply. Well, US citizens were using that, saying that their understanding of what Native means. And it was meant to mean us, tribal people. And so you don't see that often used on the census anymore, or things like that, applications. However, you'll see we have a Native American Law and Sovereignty Institute. We use it to as an umbrella term for both tribal law and US federal Indian law. So both as Native American law.
Brittany Hartos notes that when she was first registering for school as a young child as both American Indian and white, she was told to use white as the race and was always counted as white, including as of today, and asks whether you think this is a result of the history you described by getting rid of the Indian and saving the human.
Okay, so this is a big issue we have with state-run institutions. So tribal governments have domestic jurisdiction, and domestic jurisdiction includes tribal citizenship and tribal membership. And the US flipped that on us as well. So with the, it's also called the Snyder Act, I can't think of the name of it now, Indian Citizenship Act of 1924, the US stated that all American Indians were naturalized citizens. So now if you're native and born in the United States, you're a US citizen after 1924. However, the US government requires you to prove that you're an American Indian. And the US government came up with blood quantum. So we're the only people, human beings, with a pedigree requirement. So we have to prove that under Bureau of Indian Affairs standards that we're a quarter Indian blood or more. And these provisions were put in the tribal constitutions. So it is difficult to amend tribal constitutions. And so often the tribal membership rolls, the lists, require that you establish your blood quantum of a quarter or more. Now the Cherokee Nation doesn't have blood quantum, which is, I think, a good thing. They just have descendancy. So they say, here are the government rolls that were created in the late 1800s, early 1900s. And if you can, through birth certificate, show ancestry to that government roll, you can enroll in Cherokee Nation. So it's a lineage. A lot of other tribes haven't done that yet. And so we have to prove our blood quantum. And so that means that if you have a person who's Dakota and a person who's Navajo, and they're both 100%, and they marry each other, their child can only enroll in one tribe, and now they're half. So now you have a child that's half Dakota, but all of their blood is Indian. That child marries someone from another tribe. Now their child, if they want to be enrolled Dakota, is a quarter. So in 3 generations, we call that paper genocide. You've lost Indian status. So on the census, if you count American Indian and anything else, American Indian doesn't count. But we also have the situation where people claim to be American Indian without the affiliation really to a tribe. And that came up politically with Senator Elizabeth Warren claiming through DNA that she thought she was Indian. That's not the way you do it. And so tribal governments insist that you enroll in the tribe to be recognized, but state institutions and the US Census allow for self-identification. So you can have inflated numbers for diversity that don't match tribal government citizenship. So that's a real issue for us. And we also call that box checker, where people are checking the box to receive benefits as diverse people or as American Indians, but are not enrolled in a tribe or cannot prove lineage.
Do you see any other tribal nations using the McGirt decision to assert their reservation boundaries?
So this decision came down July 9, 2020. I expect we're going to see a lot of litigation.
What are the tribal stakes in our pending election?
Huge. So the current president, President Trump, when the Indian Gaming Regulatory Act was passed back in 1988, he opposed it and he called on senators to not allow it to go forward. He opposed the Pequot Casino in Connecticut as a competitor, I guess, but he also said that he didn't think that the Pequot Indians looked Indian. So his understanding of tribal nations, I think, doesn't go very deep. His use of an American Indian woman, who I say was, the first missing and murdered Indigenous woman, Pocahontas, that's not her real name, it's Mato Tawas, as a political insult, doesn't show respect, government to government respect. We've seen him open up public lands and sacred sites that are on public lands for drilling and other extraction. He stopped the tribal nation US White House meetings. The Bureau of Indian Education oversees the tribal charter schools, and under Betty DeVos, we see them pushing to open the schools in opposition to CDC guidelines. So plenary power. Exercising plenary power means that tribal nations are at the whim of some of the executive power. And so it's not been a very good 4 years.
Do you feel that there was a relatively recent change in public opinion regarding the rights of Indigenous people? And if so, what do you think the reasoning is for that change?
I'm deep in this, so I don't know what the mainstream thinks. I know that, for decades, we've been trying to get the Washington NFL team to stop using a racial slur, and that finally happened. I would say that we often express unity with social justice movements, and we're often left out of conversations. So there was a recent Women of Color in Law School study that came out by two major national legal institutions, and they didn't include American Indians in the study. I wrote an op-ed about that, and we're actually going to have a webinar on November 10th where Native women are going to talk about their law school experiences. But the feedback from those institutes was that we weren't statistically significant to be included. And so again, that's not perpetual peace and friendship. That's not seeing us as treaty partners or in a permanent neighbor relationship. That's telling us we don't count, we don't matter. And that's led to what we call the missing and murdered Indigenous woman crisis, where we're invisible. and no one cares. And so that's why I keep going back to educate. Please educate.
What do you feel, if anything, is owed to the tribal people of the United States other than returning the land?
So we'd like the treaties to be enforced. And we would like to stop being seen as an enemy. We would like perpetual peace and friendship. We would like, and you're asking me to speak broadly, I should just say I'm not an elder, and I'm saying this as my own opinion as a law professor and a scholar. But I would say tribal nations would like the history books to be taught accurately and treaty relations to be taught. We would like to live with the United States. One of the images is linking arms together. We would like to have our lands acknowledged, returned. We would like our sacred sites to be not tourist attractions. We would like to have our languages supported. We would like our perspective to be noted. We would definitely want free, prior, and informed consent as the legal standard rather than plenary power. So those are a few things.
You started to do this before, but can you comment more on the perception of the team names Washington Warriors and Kansas City Chiefs?
Anything that opens up a people to humiliation and mockery should not be something that a sports team adopts. And so we see with the KC team. So I was born in Topeka, Kansas. I would love to be a fan of the KC football team, but I cannot when I see their name encouraging people to wear mock headdresses, which is a tradition from my people, and do things like they call it the tomahawk chop and mock us. It's insulting, it's dehumanizing. And we also have the American Psychological Association joining us in stating that this representation over and over again in mainstream media and on TV has a serious self-esteem impact on our youth. We also have the highest rates of suicide of any people in the United States. We have high rates of alcoholism. We have lots of intergenerational trauma that we're dealing with without having contemporary expressions of mockery to hurt our children.
Would you support reparations for your people in the wake of these atrocities that you have been speaking about?
Again, the treaty payments were stolen from us and given to Indian boarding schools. So that money is owed. The United States took reservation lands from tribal governments and allotted them to individuals. That money is owed. Under the law, we're just asking for the United States to give accounting under the law for the things the United States has done per treaty agreements. So calling it reparations really puts it into a different context. We're asking for enforcement of the treaties. That's why I keep going back to this. This was a legal relationship that we still have, and it's nation to nation, and the United States has not upheld its end of it.
Thank you. Yeah, in regard to education, what do you believe is the most imperative in order to change the conversation at the national level?
Treaties. No point in this talk. People, I wish that the public schools were teaching our young people, our children, that the United States has a treaty relationship today with tribal governments today and stop talking about us as enemies and hostile people and savages. This all comes from those papal bulls, pagans and infidels. Stop it. You know, the United States is now supposed to be following the US Constitution and the rule of law. Stop teaching this to the children. I have a 16-year-old son in high school, and he entered ninth grade in honors ninth grade class, English class, and was assigned summer reading. And the book he was assigned was set in the 1950s and had recently won a Children's Authors Award. And in the book, there were, and he kept bringing it to me and showing me, there were at least 6 references to long-haired stoic Indians, to playing cowboys and Indians, to Sioux, and you know how hostile they are. This is last year. This was being taught to the honor students. I did start a conversation, and it was very draining on me. So we would ask our allies to step up and help. Look at the curriculum in the schools. But they did decide, after untold number of meetings and emails and conversations, to not have that book taught again. But there are other books, and now he's in AP US History. And it's just demoralizing. So that's number 1. Teach the treaty relationship, and we have tribal governments.
Are there any tribes that are not covered by treaty? And if so, would that focus, you know, somewhat exclude them?
So remember that in 1871, we have this appropriations rider that said, we aren't going to fund anything if you call it a treaty. So from then on, we have executive order and federal law, basically reservations. So when we talk about the treaty relationship, we include them. So they are part of that nation-to-nation status, even though now they didn't have what's called treaties because it was after 1871. So we're all part of the nation-to-nation status. And then I told you there are some tribes that are still not federally recognized, and the Mashpee Wampanoag have fought for generations and finally were federally recognized in 2007. That's something anyone in Massachusetts could get on board with. Show your support for the Mashpee. And now, you know, they have the Trump administration saying that their reservations rescinded. So by talking about the treaty relationship, you're talking about the tribal viewpoint towards the United States, the sovereign to sovereign relationship, the nation to nation relationship. And I don't see it as excluding those tribes that entered into agreements with the United States after 1871.
Thank you. We're drawing to our 2 o'clock class close, so I'll thank you so much for this unbelievably educational talk. I'll conclude with one last question. How might a student become involved in efforts to have legal recognition or reform of the United States treatment of tribal nations changed? And, you know, let you sort of end on that note to pass along some information to our law students. And again, thank you very much for this really enlightening and obviously, you know, really provoking talk, because, you know, this is a very sad component of our nation's history.
So I would say, as a law student, number 1, and with all due respect to all the law school deans, ask your faculty to have an Indian law class. Ask them to either hire a Native person who is a lawyer and can teach an Indian law class, or a scholar in Indian law to teach that class. With our program at Mitchell-Hamlin, we're online. So we have a blended learning option that is online and has been pre-pandemic. Our Indian law class is online. We have an advanced Indian law class, we have an intro to tribal law class, and you could always reach out and see if you could take that class. Usually law schools have a policy to allow you to take at least one course at another law school. So if you're really interested, reach out to the law schools that do have Indian law programs or Native American law programs and see if they have an online class you can take. I'm a huge supporter of hire a Native faculty member. And often we're tapped for guest lectures in all the other subject areas because tribal law is involved in every subject of law, every area of law. And so I would say reach out and hire a Native American faculty law member to your faculty. But as law students, of course, here's this book, and I invite you to use your status as law students to ask for a class.
Thank you so much, Professor EagleWoman. It was a wonderful talk and definitely very, very thought-provoking. We appreciate your being here with us today.
Thank you so much. Padama Yaye, and take care.
Thank you. You too.